It's Monday, July 1st, 2024, and welcome back to Matters of Policy and Politics, a Hoover Institution podcast devoted to governance and balance of power here in America and around the world. I'm Bill Whalen. I'm the Hoover Institution's Virginia Hobbs Carpenter Distinguished Policy Fellow in Journalism, but I'm not the only Hoover Fellow podcasting these days. If you don't believe me, go to our website, which is hoover.org. Click on the tab at the top of the homepage. It says commentary. Head over to where it says multimedia, and it will come about a dozen or so audio podcasts, including this one at the very top of the list. That's because I try to get the top of the talent at the Hoover Institution, including today's guest. That would be John Yoo. John is a Hoover Institution visiting fellow, as well as the Emanuel S. Heller Chair in Law and Distinguished Professor of Law at the UC-Berkeley Law School. When he's not teaching in the classroom or on television trying to make sense of legal matters and court rulings, John is a writer, and that includes a book released last summer. It's called The Politically Incorrect Guide to the Supreme Court that he co-authored with Robert J. Delahunty. It explains what goes on inside that building, past and present. It also includes the best and worst justices, a recap of controversial decisions, and the court's future. John, welcome back to the podcast.
Oh, great to be back, Bill. And you have perfect timing. You have a nose for the Supreme Court and its schedule to schedule this podcast on the biggest day in the Supreme Court's year and maybe of the last 10 years.
Yes, to quote Bernie Sanders, huge. That's why I have you because speaking of controversial decisions, John, we have a very big one. We're going to get to that to start the podcast. The second half, I want to talk to you about the 4th of July because I think you have a rather unique perspective on what Independence Day stands for and means to this country. But let's begin, John, with the High Court, which not too long ago, about 90 minutes ago, issued its long-awaited ruling in the question of presidential immunity. John, this is the case of Trump v. United States, which I believe the oral arguments were last April. What is issue is this: whether former President Donald Trump could claim immunity from the 4 federal felony charges leveled by Special Counsel Jack Smith, who's accused the former president of conspiring to derail the peaceful transfer of power and thus disenfranchise voters in the 2020 election. Trump's argument, John, is what he did fell under the umbrella of his official duties as president. The pushback was no, Mr. President, these were not official acts. The matter made its way to the Supreme Court, John, and now we have the ruling. And correct me if I'm wrong here, because you're the legal brain and I'm not. But as I interpret it, John, the court upheld the notion of presidents having immunity for official acts. But it also sent the case back to a federal district court to decide if Trump's post-election actions constituted just that, official acts. So it seems to me, John, that we're back to square one, which is whether and how to prosecute a former president, especially one who's still politically viable, for things that happened during the presidency. So here we go, John. So I want you to look at this from 3 standards that I always do with Supreme Court cases. 1, is it a ruling, in your opinion, one of common sense? 2, is a court's ruling clear? Is there clarity? And 3, is there closure? So go for it.
In the interest, of not sounding like the defendant, in this case, Donald Trump, but I have to say today, Donald Trump has won a greater victory in the Supreme Court than I can think of any president before any Supreme Court at any other time of our history. This may be the most pro-executive power decision in the history of the Supreme Court. Usually when presidents get dragged to the Supreme Court, bad things happen to them.
Nixon,
like, for example, Clinton versus Jones. When Bill Clinton appeared, he lost.
Nixon and the Watergate tapes, 8-0.
Yes, that's the next case I was going to raise, which is the most close to this. Nixon versus United States, where Nixon had to turn over the Watergate tapes. And before that, Youngstown, Sheet and Steel 2 versus Sawyer, where Truman tried to shut down the steel, not shut down, take over the steel mills during the Korean War. Mm-hmm. President lost that one too. So usually presidents lose when they get dragged before the Supreme Court. Trump was no different. When he was president, he lost a series of very important decisions at the end of his presidency. This case is a resounding victory for the president. I'm very pro-presidential, obviously, in some of my writings. Even I did not anticipate that he would win so profoundly. So you asked, does it make common sense? It makes a great deal of common sense. However, common sense is not always rooted in the history and text of the Constitution. The common sense idea is that a president shouldn't be able to go after his or her predecessors, right? Joe Biden shouldn't be able to prosecute Donald Trump for things he did while he was president, because you will launch a reciprocal tit for tat, right? Every president then going after every previous past president, which is what we're seeing in places like Brazil and South Korea even today.
Right.
That makes common sense. I have to say, though, that the dissent makes excellent points that, well, if you look at the text of the Constitution, if anything, it suggests that presidents don't have immunity. Congressmen have immunity for what they do on the floor of the House or the Senate. And actually, the constitutional text talks about being able to prosecute presidents after they leave office and only being able to impeach them while they're in office. So, but it does make a great deal of common sense. And that's really the appeal that the Supreme Court majority, led by Chief Justice Roberts here in 6-3 decision, makes. He basically says, look, the presidency would not be able to function. Mm-hmm. We would not be able to have a real separation of powers if you could prosecute a president, because imagine a president, an unpopular one, for example, who later becomes subject to laws passed by Congress to go after him, to presidents who want to use those laws to prosecute him. You could really persecute a president. And the court tries to make clear, I don't think the dissent buys it, but they try to make clear this doesn't have to do with Trump or whoever, any individual, or Biden, or whoever's in the office. It has to do with allowing the institution of the presidency to function. It won't be able to function if you're always looking over your shoulder, worrying about what president's going to come after you and wants to throw you in jail. Now, closure, this is the interesting thing. Even though Trump has won this resounding victory, the court does leave the door open for the January 6th prosecution against him to go forward, because it says immunity does not apply to acts you take when you're not in your official presidential capacity. And President Trump's lawyers even had to concede at oral argument that some of the things Trump has been charged with involve things he did as a candidate for office, not as an official. And there the courts have said, I think unanimously, that you're not acting officially. So an example would be, what if Trump was calling the heads of the Republican parties in different states and conspiring with them to overturn the electoral votes in those states and replace those votes with his own electors? The court suggests, it doesn't hold it, the court suggests, well, that's probably an unofficial act, and so there's no immunity. So that part of Jack Smith's special counsel investigation could continue. But I have to say, this is I think the closure you're also asking about, which is a closure on the whole lawfare against President Trump. It's very hard to see how the January 6th prosecution, the Eileen Cannon case that's sitting on the classified documents in Florida prosecution, by the way, this case also applies to the Georgia prosecution too. Even though that's in state court, it's hard for me to see any of those cases getting to jury verdict by the election. And so I would think the closure could really come about from President Biden and Attorney General Garland. If they were playing this smart, what they should do is say, the Supreme Court has now made it impossible for us to get the special counsel's job done. So we're going to drop all this and just throw it to the voters in November. Drop the lawfare campaign, because it's not going to work. The Supreme Court is disgusted with it. That's another thing that comes through in the majority opinion. They have had it with lawfare, and they have done as much as they could have done to put an end to it.
Mm-hmm. So Trump is technically not out of the legal woods. Cases could still go forward. But if your vision, if you don't like Donald Trump and your vision was to put the guy on trial before the election, that appears to be over now.
Yeah, exactly right, Bill. The court goes to great pains to say a lot of the things in the indictments against President Trump can't be determined all the way up here at the Supreme Court level. So we're sending the case back down to Judge Chuckman here in Washington, D.C., to go through every single act in the indictment and decide, was it official? Was it not official? And even if it's just again the nitty-gritty, then the court actually says, if it's official, you then have to decide, was the president acting within his or her core presidential powers, for example, like giving out pardons, or was the president acting in an area where he shares power with the Congress? So for example, an example would be appointing officers. Mm-hmm. And then it says in the first and core areas, president has absolute immunity. You cannot prosecute him. Interestingly, this seems to suggest to me that the president can give out pardons for money. He can't be prosecuted now ever.
But he could be impeached for that, John.
Yes, you can be impeached, but you
I mean,
can't be
and that gets to the
prosecuted.
idea of checks and balances here. So, okay, maybe under immunity you can't prosecute them, but if the blaring headline of the Washington Post and New York Times is, John, President gives $1 million, takes $1 million bribe for Whalen for ambassadorship, yeah, you can get tossed for that.
Yeah.
They would
So
just
this is
call a high
interesting.
crime and
Remember,
you'd be gone. Yeah.
yeah, remember Bill Clinton? He allegedly did this at the end of his presidency, right? He gave uh, a pardon to a fellow named Mark Rich, right? A
Yes.
guy who was on the lam, right, for federal prosecution for many years. And the story was he did it so that Mark Rich's wife, who controlled his money, would support Hillary Clinton, right, in
Right.
her race for the Senate. So suppose that was all true.
Mhm.
It seems to me, according to this decision, Bill Clinton could never be prosecuted for that, and he couldn't really be impeached for it because he did it on the last week of his office. He did it on the way out the door. I think if I read the opinion carefully, you just the system can't punish a president for that anymore. He will live in infamy, or she will live in infamy, but she can't be put in jail.
But now, John, we're getting in the weeds of the presidency. Bill Clinton, for example, when he left office, he was a termed out president. He could not have run for president again, whereas Donald Trump could still run for president, and Donald Trump was impeached after he left office. So I could say, well, if Bill Clinton were like Donald Trump, still a viable candidate, then maybe a Republican Congress would try to impeach him on some grounds of that. And so away we go.
Mm.
Question for you, John. Professor, let me ask you a question as a legal student here. Three of the justices were appointed by Donald Trump. Why did these three justices not recuse themselves from a case that directly involved Donald Trump and his political chances?
Interesting. So the one thing is, as opposed to other courts, the Supreme Court only has 9 members. And
Right.
so the rules on recusal work differently for them. For example, if they step down, you can't call in another judge to replace them, which you can do in the lower courts. And so they actually have to be much more careful, in a way, less generous to the recusal rules. Because there's only 9 of them, and any one missing one of them can make a huge difference. But two, it's never been thought that because a president who appointed you has cases before you that you have to recuse. Think about Neil Gorsuch, who's appointed in the very first year of the Trump presidency. If the recusal rules were read that way, he'd have to recuse himself basically from every case involving Trump.
Right.
That would be like, given a lot of the cases of the Supreme Court involve the United States government, you'd have justices who couldn't sit on like half the most important cases every year for quite some time. So instead, the idea is, is there some kind of interest that prevents those justices from being impartial and fair?
Mm-hmm.
And I don't think there is. I mean, several of these Trump-appointed justices have from time to time voted against President Trump's interests. For example, in this case itself, they all agree that President Trump can be tried for his unofficial conduct,
Right.
which is quite harmful to Trump's interests, were it possible to get that in under the wire of the election. So I don't think recusal is required. And then there have been this particular attacks on Justices Alito and Justice Thomas, and as you know, I clerked for Justice Thomas. I find those claims to be almost frivolous. They don't really involve the justices themselves. It involves their wives, right? They say, "Oh, Ginny
But I asked the
Thomas."
job because a person out there without a legal degree, a person who just is kind of trying to make sense of all this cacophony of noise coming out of this decision. That's one of the first places detractors go to say, well, geez, 3 Trump justices voted on Trump's behalf, and it's different from Bush v. Gore in this respect, because there you had a 5-4 decision back in 2000, but none of those justices were appointed by George Bush or Al Gore. So here, this is the awkwardness of the situation in part, I think, because you have 3 Trump justices involved in a decision involving Donald Trump.
Yeah. Let me also say, having been there, having known them, actually, the 3 justices you're talking about are people I've known for a long time. I mean, I'm of their generation. We were all in school together, clerked for similar judges. In
Right.
fact, I rented Brett Kavanaugh's apartment when he moved out of law school. I moved in, and I can tell you there was nothing in his closet or under his bed. Believe
No
me.
beer cans.
Although, as far as I can tell, all the guy ever did during law school was play intramural basketball. So there's your preparation for the future for the younger students listening. The other thing is the justices, I really deeply believe this, is they don't care about who the president is in terms of person. If they have an allegiance to anything, it's ideology, judicial ideology. For example, opinion like this: do you look at what the founders thought, or do you look at what our the court's recent precedents are? That has almost nothing to do with the individual who's in the office. And in fact, I've noticed that justices and judges, I think Justice Scalia in particular loved doing this, voting against the side that everyone would have thought politically they would have liked. So I think Justice Scalia got all kinds of pleasure, for example, when he would issue decisions against law enforcement, because everyone assumed conservative judges were pro law and order. Or Justice Thomas has often issued some startlingly libertarian decisions about whether you can use electronics to surveil people for drug dealing. And people think, oh my gosh, Justice Thomas, he's pro law, so pro law and order. That's the way they think about it, not like, oh, I'm going to vote for or against Donald Trump.
A quirk in the calendar, John, has the court releasing this decision on Monday, July the 1st, a day after the June 30th deadline, usually the end for doing this, though. But why do you think, John, the court waited until the end to do this? And explain a little bit if the court sits down and thinks about the timing of how to roll out all of these decisions.
I do think the timing you saw of, if you were to say, of a political nature is really up to the Chief Justice. What the opinions coming out and everything ultimately is up to him. And I detect good sense in Chief Justice Roberts in delaying the opinion so it did not come out the same day as a debate, right? Because then, maybe Roberts wishes to elevate the nature of the presidential debates and get them talking about the Constitution. But even there, he saw the better sense of not issuing the decision during the period of the debate. Now, the reason why this came up at the end is one is it was an emergency. So this case got accelerated way faster than almost all other cases would be heard. As you noted, Bill, the oral argument was just in April. The case was granted just a few months before that. Usually the Supreme Court takes about a year or so to fully consider and vet cases, hear the oral argument, issue the decision. So this case went up 3 times faster, at least 3 times faster than a normal case. But then the second, if you look at the decisions, the dissent is actually quite lengthy and extensive. There are also several other opinions by other justices. The majority opinion, as I said, the majority opinion is one of the most intense considerations of the nature of the presidency in the history of the Supreme Court. I mean, it will agree with it or not agree with it. This will be the most important opinion about the presidency by the Supreme Court for the next few decades. And so they go, like the justices, Bill, are just like students trying to hand in their papers on the deadline. They go right up to the very last minute they're allowed to keep working on their dissents, concurrences, answering each other. You'll see that the majority and dissents and concurrences are all responding to each other. So they waited to the last possible because I think they all wanted to get the last word in on the most important Supreme Court opinion on the presidency, maybe in the history of the country. So it's no surprise it came out a little late, a little past the deadline. They got an extension, 1-day extension. We'll give it to them.
One thing I'd point out to students of politics versus students of the law is that if you're a politician handling a political matter and you have something that's controversial and a bombshell and you just want to walk away from it, you dump it at 5 o'clock on a Friday and call it a weekend. But here, instead of the Supreme Court not doing it on 5 o'clock on a Friday, because if you told me before we came on the air, the Supreme Court releases decisions at 10 a.m. sharp, they did this at 10 a.m. on Monday. And Roberts could not have foreseen this, but given what happened to the president on Thursday night in that debate, followed by a Friday, a Saturday, and a Sunday, and a Monday morning of just endless speculation about the health of his campaign, the health of the president, what's going to happen in the election, and Donald Trump's fortunes rising. Now on Monday morning, he kind of adds a log to the fire with all that by doing this. I'm not saying he did it on purpose, but it just plays out that way because it rolled out on Monday.
Well, this is part of what you were talking about earlier about the rhythm, the schedule of the court. Every year, this is the case. The court always likes to get its decision out before July 4th weekend. And so, and since nobody, all I'm going to be doing this week, I don't know about you, Bill. I know you're in the South, you're going to be, I don't know, eating whole hogs or whatever. But, those of us stuck in California, we're reduced to these miniaturized meat packets they call hot dogs and hamburgers these days. So most Americans are going to be taking a few days off and they're going to be enjoying themselves, having a cookout. And the Supreme Court cases are like the most important things to talk about for at least people interested in the law every summer, because they always finish their business right before July 4th. They also, by the way, have the academic calendar. So they're all dispersing now. They all want to get out. That's the main reason they have to finish, is because they all usually traditionally want to get out of town for July 4th, and you don't see them again till the first Monday in October. So this is the start of their their long summer vacation. I suspect some of them may be wanting to find out some undisclosed location to join Superman and hang out because of the bomb they just threw into the campaign. Can I also say one last thing is, I don't know if you were going to get into this, Bill, is how what we saw with the debate and the political angles to this and the legal angles intersect or intertwine is this it seems to me, makes it much worse for Biden, because if Democrats thought this whole lawfare campaign against Trump was going to somehow pull their bacon out of the fire,
Right.
It's not going to now. So that means the debate became even more important, right? All because this really, I think, the Biden versus Trump, or whoever, fill in the blank versus Trump, is really going to have to be decided at the ballot box now. The Justice Department, prosecutors, Fani Willis, juries, they're not going to save the Democratic Party from what's coming in November.
Yeah, take us inside the court's thinking in this regard, John. In December of 2000, the court has to, in effect, decide the outcome of the presidential election of Bush v. Gore. And I don't think they enjoyed doing that. And now here we are in the summer of 2024, and they had to weigh into Trump v. United States, which may or may not decide the outcome of this election, but it does have an effect on it. Is the thinking on the court, John, that, we're done with this now, let's hope it's another 25 years before we have to weigh in on a national election?
That's a nice point, Bill. I think if you were to pull back from the legal nitty gritty and say, how's the court thinking about this as a political actor?
Yep.
Every time the court has decided a case involving January 6th or Trump or the election in the last year, they've done it in a way to try to pull back the courts, trying to get it out of the morass. And so here, I think the court could say, Chief Justice Roberts, let me say this, I think is the way Chief Justice Roberts thinks. Chief Justice Roberts has been to the Bill Whalen School of Politics. I think he thinks the way you're describing, Bill. I think he would say, look, no one can accuse us now of deciding this election. Trump or Biden will win in November. It won't be because of the Supreme Court. In fact, what we're doing is we're, in a way, delaying things. If you look at it, the court has delayed, the lower courts have delayed a lot of these prosecutions of Trump so that they will not take place before the election, which means, say Trump loses, he will not be able to accuse the Supreme Court of having put its finger on the scales against him. And if Biden wins, he can't say, oh, I won because of the Supreme Court. The court is going to have been out of it, I think, fairly so. And I think that's because that's been Chief Justice Roberts' agenda. The thing is, and I think the other reason it's succeeding in a way is nobody's talking about these huge Supreme Court decisions that have been coming out this week, which in any normal year, but Trump versus Biden would have been considered earth-shattering. For example, the court last week issued a decision overruling deference to federal agencies. That means the courts are going to sit there and closely scrutinize all of these thousands of regulatory decisions coming out of the executive branch agencies. Earlier that week, they said that these agencies aren't going to be able to use their special courts against Americans, that all Americans have the right to go immediately to federal court to challenge any agency action. They don't have to wait and sit for years and years before these sort of kangaroo courts that have been concocted by these New Deal agencies. Any normal year, this would be considered earth-shattering changes in constitutional law. Nobody is even talking about it.
And then sometimes it goes back to the issue of closure, John. They don't quite settle something. For example, a case really overshadowed today was the one involving state laws overseeing social media content. And there, John, like the Trump case, they sent it back to a lower court. And now is that the court just saying that, we want you guys to review this a little longer and think it over longer before we weigh in? What was the rationale there?
So there's legal rationale and political rationale. Legal rationale is they sent it back down to the lower court here, the one in Texas, because they felt that the lower court had not fully considered all the arguments. There's a lot of important First Amendment doctrine, the court says, that the Fifth Circuit did not consider. And so the Supreme Court doesn't want to get ahead of ourselves and decide things before they've been fully ventilate. The Supreme Court justices actually use the word percolate. I don't know if anybody remembers how we used to make coffee in this country, but we didn't put pods and machines and let the robots make our coffee, right? We used to have this percolation. So the justices like the idea of issues percolating below until they're really perfectly set up for the Supreme Court to decide. And I think that's some of it. They felt like maybe they rushed into, the lower courts have been rushing into the social media issue too fast, but they did give a strong sense of how they'll come out. They basically said, we don't see how the states have a right to tell private companies, even private companies involved in speech, what kind of views they have to accept or not accept. And this is, Bill, I appeal to your Irish origins. The great case they appeal to is the Supreme Court case about the Irish parade in Boston, the St. Patrick's Day parade in Boston. And they compare, this is so funny because, again, this is just them saying this is how you might think about it, lower courts. They say social media is like a parade. And the parade organizers, they decide who gets to have a float, who doesn't get to have a float. And the whole thing is expression of speech. It's an expression of points of view. But you're the parade organizers. You can still, in that case, it was, I think they excluded a gay Irish parade float. But they basically said the parade decides who gets to be in the parade or not, what points of view or not. Like you wouldn't allow, I would think, float in the Irish parade of a King Charles III, King Charles III float. So the court actually said, that's a good example. You're a private actor. Even though you exist for speech, you still have the right to decide who comes in or who goes out. And the court said, the lower courts have to explain why social media is different. I think you're right, Bill. In terms of the daily lives of Americans, in terms of what we do every day, in terms of what we're going to be doing for the years to come, that decision may be more important than the case in Trump versus the United States. But
very much so.
I don't think anyone's going to talk about it much, even though it's really a very important decision because of the Trump November 2024 case.
Right. And that's why I was thinking about the timing, because if they'd done this on Friday, there were very important decisions involving regulation that came out on Friday that, again, for, eggheads like us are going to have huge ramifications down the road. So you don't want those overblown. John, so here we are.
One small thing that actually ties into your point. I'm sorry, I didn't mention it earlier, is actually the court ducked a lot of major cases this term. Okay. They ducked basically 2 abortion cases, the case about the abortion pill, mifepristone, whether that had been properly authorized by the FDA. And then this other case out of Idaho involving whether if you take Medicare funds, a hospital has to perform emergency abortions. In both of those cases, the court said, we're not going to decide this now either. So maybe I put the broader point, Bill, to I think fully answer your question is I think what the court did is it was saving its political capital. In this sense, I think they do think like politicians. You have a limited sense of political capital, and they're going to throw it all into the Trump case. And so to do that, they decided to lower the temperature, maybe get out of other controversial issues like abortion. To the extent they're pushing forward this year, it's in this trying to constrain the administrative state, or what Trump likes to call the deep state, that they've been doing for 20 years now. And nobody's going to get too upset about that compared to the Trump case. The abortion issue, if they gone and decide the abortion issues, that might have led to more calls of who are these jokers and why are they deciding all these important cases for the country? So the way they think is we're going to narrow what we're doing and throw all our chips on the Trump case in the hopes that the American people accept what we say and not challenge us the way I'm afraid some critics want the court to be challenged.
And John, how did they decide the caseload for the term? To sit around a round table and show of hands? How many people want to do this case? How did they?
Oh, it's so I don't know what you think, Bill. You worked in the White House. I was in there a lot. I worked in justice. I worked in the Senate. Of all the branches in government, I like to say the justices are the ones who actually do most of their own work.
Yeah.
Most of the written things you see are them working with 4 clerks, but a lot of that is their writing. The way they decide cases is the first time they discuss a case together is at oral argument. So when you listen to that's why oral argument is important. When you listen to oral argument, you're hearing them talk about the case for the first time with each other. Then right after oral argument, they go into what's called this little conference room. No staff allowed. That's amazingly no staff, just 9 of them. They sit down and then they go and discuss the cases, and they go in order seniority. So the Chief Justice goes first. So in Trump case, he would have gone first, said, I vote to have immunity for Trump, and this is why. And then it goes down from most senior to least senior, and they vote. And so within a few hours after the oral argument, the court knows how it's decided the case. And yes, as you say, they raise their hands, but nobody knows except them in that room, and then their clerks afterwards, who they get to help them. And the only reason as a clerk is the justices need your help to help do research and draft the opinions. The amazing thing is other than that terrible leak of the Dobbs opinion 2 years ago, which we talked about on your show, there
Mhm.
has never been a leak like in Washington. That's like normal in Washington. You don't see people jockeying to change decisions by leaking early. Oh, this happened or that happened. Nobody knew that I mean, I kind of thought Trump was going to win just on because of what we discussed, some of the cases they were kicking out early, some of the things they were lowering the profile, but nobody really knew until 10 o'clock this morning that Trump, that's unbelievable for Washington. How many secrets can last that long in Washington? And I think it's because the justices do their work. They do the work themselves.
John, for the past 72 hours, I've been reading endless speculation about President Biden and what comes next after the debate. Some of this serious, some of this kind of frivolous, but it's fascinating to read because besides just the game within the game of what happened to him, there's a game within the game of, okay, if you wanted to get Joe Biden off the ticket, how does it happen? It's incredibly complicated. I won't spend too much time getting to pledge delegates and that all kind of stuff.
Mm,
But timing is a really fascinating thing here,
mm,
given state rules and so forth. Let me ask you a timing question regarding the Supreme Court. And this is just kind of a wacky thing, but it just crossed my mind the other
mm,
day. And it goes like this. You're a Sonia Sotomayor, and you're now thinking about how much longer you want to stay on this court. And maybe
mm.
you could survive. She's had health issues. She's had diabetes, I think, for a good portion, not all of her life, but I don't think she is in the same health condition as Ruth Bader Ginsburg right now at this point. But maybe you're thinking
Yeah,
about
we
your
hope not.
longevity.
Yeah.
Right. But maybe you're thinking about your longevity, John. Maybe you're thinking about now the improved chances of Donald Trump winning this election. And maybe you're thinking this, maybe I should get out right now before there is a Republican sitting in the White House. So here's my question, my friend. We're sitting here on July the 1st. Could she all of a sudden announce that she is going to step down? And if so, John, could they actually, would the timing work out? Could they get a confirmation hearing done between now and the election? Could they get a replacement? Again, this is just kind of a crazy theory of mine, but since we're in the middle of conspiracy theories right now, could that actually happen? Is it possible?
So, Bill, first, it's not a crazy idea. There are several legal commentators,
Right.
progressive legal commentators, who've been calling on Sotomayor and even Justice Kagan, who I don't even think is
Right. But
65 yet, to
that was a
step
while,
down.
that was a few months past, John. But now here
Yeah.
we are now past the court session now, and there's just,
Yes.
unlike
No,
Ginsburg dying right before the election, could she actually, I mean, it would be
no,
unprecedented.
you're right, Bill, because the more it looks like Biden's going to lose, right, the more you would want this to happen if you were progressive, right? Because otherwise, you're handing the seat potentially over to Trump or whoever Trump's successor are.
Right.
So it is possible. Go back. So actually, you're asking more to put on my former executive and legislative branch hats on. Uh, President Trump was able to get Amy Coney Barrett through in
Right.
about, I would say, vacancy to confirmation in 3 months. And so I think you could do that as a matter of past practice. But think about the things you would need. First, I think you need a president who's on top of it. And one thing Trump did in his first term was he kept his promise to conservatives to be very much on top of getting the right people on the bench.
Right.
Biden, I gotta say, after that debate on Thursday, I mean, how are you confident that he would be able to come to a quick conclusion on who should be appointed to the Supreme Court? I mean, and then the other thing is you got to give a lot of credit to Mitch McConnell back then, 4 years ago. The Senate majority was really unified, right? I mean, you have to, in order to get all the stuff behind the scenes done, background checks, investigations, reading all the opinions, scheduling the hearing on the committee. I was general counsel of the Senate Judiciary Committee, and then the floor vote. I mean, you got to be disciplined. You can't have dissenters, right? If there had been an Arlen Specter around who said, I'm not so sure about this, the whole thing collapses. Do we see a united Democratic Party right now? It is so fractious, I think, and there's so much infighting going on. I don't know whether the Senates and the Democrats in the Senate would be able to display that kind of discipline.
Well, John, I think
You could do it constitutionally, legally, but
right.
politically is the question mark.
Well, they would stick together and vote on the nominee, John. But the question is, who would be the nominee? And no, I'm not going to say Kamala
Exactly.
Harris because that's like a ridiculous pool game. I think Vice President Harris.
Yeah, no, I think that's what I mean about unity because the president is not in charge of his party. That means this is what I would witness all the time in the Senate is then you would have different factions within the Senate trying to get their nominee pushed forward. And part
Right.
of that game would be if you don't put the guy I like up, then I'm going to delay things. That would just extend the whole period of picking a president. I can't, I don't see them as that unified. Maybe they would care a lot about, it would also, what would also be an interesting sign of, Bill? It would be an interesting way of taking the temperature of whether the Senate Democrats think that Biden's going to win. Because
Yeah.
if they don't think he's going to win, then they will try to act in a disciplined way and get it and ram it through.
I think also John choosing somebody would be very complicated because of identity politics, plain and simple. He has had one pick. He picked an African American woman. Do you pick another African American justice? Do you pick an Asian justice? Do you pick another woman? Do you pick somebody openly gay? Everyone on that side is going to have an idea who should be the next justice.
And those things count even more
Yeah.
when you're behind in the polls, right? Like he would try
Yes,
to
now
pick
you
someone,
have to
help him
decide
get reelected.
who gives me a bounce in the polls. Yeah.
So I'm glad maybe I'm still in the mix because I'm a member of the Pennsylvania bar.
Well, speaking of Pennsylvania, John, that's a nice segue to the other portion of this podcast that I want to get into, and that is Thursday, July the 4th, Independence Day in America. What are you doing on the 4th?
Well, I'm going to be hosting actually some friends at a club near our house in California and doing the traditional American things, hamburgers, hot dogs, hopefully burnt and overcooked on a charcoal grill like they should be, and listening to live patriotic music and watching the boats flow by on San Francisco Bay.
And does anybody yell, turn that crap down when you play patriotic music? Or,
They better not.
sorry, but this is San Francisco.
That's true. That is true. You're right. What did the president, your former president, call them? Bunch of hot tubbing liberals in Marin County. One of the great classic lines.
Well, this is part of what's unique about the 4th of July in America. It is a national holiday, John, but it's celebrated decidedly different in different pockets of the country. For example, in San Francisco, I would argue in that Bay Area, there's patriotism, but it's different levels of patriotism dependent. It's like the microclimate in San Francisco. It's kind of micro patriotism. Some areas fully embrace it with parades and so forth. Other areas just don't get excited about it. In terms of climate, it's always fascinating. It's always a question of fog, whether or not you're going to have fireworks to begin with. You mentioned I'm in the South. I'm in South Carolina. I'm just outside of Charleston right now, John. I'll be on the beach on the 4th of July. And it's a great irony for, the part of the country that began the Civil War, fired the first shot. There's a first shot bar in Charleston. I'd be glad to take you to if you want to come visit me here. But Charleston embraces the 4th of July. There's a military flyover. There are flags everywhere. There are Blue Lives flags everywhere. It's very pro-police here. So it's different. But you grew up in Philadelphia, John.
Yes, and actually, we were talking about this, Bill. My first memory of July 4th actually is a great one because I was a kid at the 200th, the bicentennial of the Revolution, and so Philadelphia did it up big in 1976, and I still remember as a little kid, I would have been, would I have been like 7, I guess? Yeah, I would have been. No, I would have been 9. I would have been 9 years old. I remember my dad taking me and my younger brother Chris to watch the bicentennial parade in Philadelphia. It's probably, I think it is actually the first July 4th that I can remember. And I can remember because it was such a big deal in Philadelphia. I mean, you had the Independence Hall, which was originally the State House, right? That was the Pennsylvania State House at first. And so Philadelphia and its history is so intertwined with the Revolution and the Declaration of Independence and the writing and ratification of the Constitution, which came in 1787, that it's ever present. It's all around you in Philadelphia. And so I think you always appreciate the founders and what they did and their bravery. And actually, I grew up 10 minutes from Valley Forge.
Right.
And so I still remember as a kid going to visit. And you can't believe, I mean, they still have the little huts and cabins preserved from the winter of 17th century. You can't believe that people lived through a cold Pennsylvania winter in those kind of conditions. But they did it because they wanted to liberate the country.
And irony of the Hoover Institution, John, arguably the two most cheerful, happiest, always laughing, joking fellows that I know are you and Lieutenant General H.R. McMaster. And what do you have in common? Sons of Philadelphia.
Is that right? Is he as sunny as I am? Well, the part of the things, if you grew up in Philadelphia in the 70s and you made it out, you had to have a very optimistic outlook because the conditions around you would not have led that way.
That's well put. The movie Rocky kind of gets that very well too, especially the scene where he's running through Philly just kind of captures what a hard Scrabble town it is.
Oh, you see, so people tell because Philadelphia now is like a lot of cities, oh, fancy pants restaurants and
That's right, yeah.
shopping. But yeah, the Philadelphia I grew up in was the Philadelphia and Rocky. So when I saw it, I was like, whoa, why are they showing home movies? But like I did not grow up in the second part of my life in the South Philly suburbs, but that was where my family first landed. Was the Southern Philadelphia Italian neighborhood is where my family first landed and lived. And if you drive there even today, you'll see it just like then. Like Italian grandmas sitting on the stoop because so hot is summer and talking across the street with each other. The street is the neighborhood living room. There's a lot of streets that are still like that. And when you go to eat there, you park in those still the same neighborhood. So that still is, I think, the dominating culture of Philadelphia is Rocky.
Mhm. All right. Let's talk a little bit, John, about freedom versus authority in America, which is always kind of a delicate balance and something which is being discussed in this election very much with the idea of democracy being under attack and so forth. And here I'm going to get into a bit of a diatribe, John. Our listeners should read a column I have coming out at Hoover this week on life in California versus freedom. It's kind of a selfish breaking the fourth wall thing that I wrote, John. But what got me going was the other day, John, I took my car in for a smog check in California, $108, which you have to pay every so often to make sure your car passes emission standards. I'm willing to pay that, John, because ultimately the price is clean air, and I think we agree that clean air is probably a good thing. But John, that's on top of a $308 registration fee that I had to pay for my 8-year-old car, which is a fee based upon the Blue Book value, which the state nails on you every year if you want to drive your car. But here's what got me writing the column, John. I took my car in for the smog check. It's a 2016 BMW, and you're a BMW guy historically as well as you can appreciate this.
Oh, yes.
BMWs have oxygen sensors. Their oxygen sensors are very kind of sensitive, finicky things. And if the oxygen sensor is not working properly, John, then you don't pass the emissions test. Or so I discovered after taking my car in, and 10 minutes after the guy checked it, he smiles and goes, "You failed." So
You
I said,
failed. Oh
so
my
I said, "How do I
gosh.
pass?" And he goes, "Well, sir, you have to get in your car and drive because it's a function of the car not driven enough, and I don't drive a lot."
Bill, you got this on. The way you pass is you give the guy another $50 and then you hit the side of the smog machine with your hand.
No, John, it's not Philadelphia. So we're in California. So what I had to do, John, was on a Wednesday, I had to jump into my car and drive my car for about 100 miles to make sure the oxygen sensor was working right. And cherry on the Sunday, John, I had to drive it at about 55 miles an hour. Have you ever tried driving 55 on a highway in the right-hand lane? Do you know what people do when you do that? It takes us back to Philadelphia, John.
It's just amazing. It's amazing you weren't given the Mad Max Road Warrior treatment by our fellow residents of
Exactly.
California.
So, John, the saga continues. So, I succeeded in getting the car driven 100 miles. It was not without incidents because part of it was driving up one side of the San Francisco Peninsula in which I live, traffic flowing, not a problem. But then going past the airport and coming down the 101, which runs north south between
Oh,
San
yeah.
San Jose. And, John, just south of the airport in San Francisco, they have taken not one but two lanes of that highway, John, and they've cordoned them off for HOV only. This is the state's way of
Yes.
trying to get people to drive electric vehicles. So now it's about 11 o'clock in the morning, and I am sitting in bumper to bumper gridlock, having to drive 100 miles an hour and getting mad. So I thought, the heck with this. Life is short. I want to get this done. I'm going to jump in the HOV lane. And then I saw the sign. You know what the fine is for driving the HOV lane, John? $493.
No way.
Way.
I
So,
drive in the HOV lane all the time by myself. I've never actually gotten a ticket.
okay. Thank you, Mr. Law Professor.
I'm a libertarian at heart.
So John, continuing with the theme, so I obeyed the law. I did not get in the HOV lane. Eventually, the traffic eased up. I finished the job. I got the 100 miles driven. The car passed, but I was just kind of really chafed by whole thing. So I went home and I thought, I need to take a walk, and maybe I'm going to take a cigar with me and puff on a cigar while I'm walking. Well, John, where I live in Palo Alto, there is an ordinance that if you're smoking in public, it is a $500 fine.
Are you kidding?
That's an expensive
You
cigar, my friend.
can't smoke in public?
If it's ruled a high
Oh
density
my
crowded
God.
space, you cannot smoke in public. $500. So I thought, okay,
I,
fine.
I volunteer. I volunteer to be your lawyer in the case of Whalen versus Newsom.
Yeah. So So I don't want to pay $500 for my cigar, John. So I figured, fine, I'll just light up fireworks on the 4th of July, which I do in California. But you know what, John? If you live in Menlo Park, which is adjacent to Palo Alto, it is a $1,000 fine if you set off fireworks and jail time. And the cops actually send out emails each year reminding you of this fact. So if you want to break the law, go ahead and do it, my friend. Maybe you want to clean up the evidence, but if you fire up a gas-powered lawnmower to do that, John, it's another $1,000 fine. So here's what I'm getting at after this diatribe about my poor, sad life in Northern California. There are a lot of restrictions on how you can live your life as you so choose. I would argue some of these make sense for the public good. The air emissions thing I had mentioned, the $500 fine for a cigar, which I think we'd agree is comically expensive. Well, passive smoke is not a good thing for people. Setting off fireworks in a dry part of the country can start a wildfire and so forth. So certain things kind of make sense, John. But there is a question here about how much the government can regulate your life and your activities versus how much you're allowed to be free. So explain a little bit from a constitutional law perspective how this balance plays out.
I'm glad you asked this on July 4th because it ties together with your earlier question. Is you sit there and you say, did hundreds of thousands of Americans give their lives in combat to preserve our right to be micromanaged by a sea of faceless bureaucrats?
Right.
Now, I actually think this brings us back to the original set of questions about the Supreme Court, because the Supreme Court, I think, is doing what it can to push back and restrict what all these bureaucrats are trying to do in micromanaging our lives and trying to restore the original Constitution. And if I was to put it starkly, the kind of government we live under now, the kind of country we live under now is the government of Woodrow Wilson and Franklin Roosevelt. They were the original progressives. And their view is life is too complicated. We have to have experts make all the major decisions in society, like with your examples. How much emissions should go into the air to keep it clean? What should people should be allowed to drive? What they should be allowed to smoke? In fact, their view was this is so important. We got to get that away from politicians who are dirty and corrupt. And so we need to create this vast independent bureaucracy and let no one interfere with it. Right? That's one vision. And that's really, we are living in that vision. That is Woodrow Wilson and FDR's vision for the country. You could say that LBJ and Obama put it on steroids, but that's one vision of how to rule the country. I think the founders' view and the view that most Americans, I think that, is embodied in the Constitution and the Declaration of Independence is we have a decentralized government. The law doesn't tell us what to do most of the time. We rely on the good judgment and reasonableness of everyday American citizens in their small communities and towns to decide basically how they want to live without the government reaching. We don't need a bureaucracy. All we need are some police, some courts, and that's about it. And that was basically the way America ran itself until Woodrow Wilson showed up. And if you look at these decisions we talked about earlier about deference to agencies, which is the Chevron decision, or about using special agency courts to adjudicate cases against the government, or earlier cases that this Roberts Courts has been deciding against having independent agencies, that every agency head must be responsible to the president or an elected official. Roberts, when you look back, these cases like the Trump case and so on, they're like blips. The major trend of the Roberts Court has been to try to cut down the administrative state. So, Bill, they have you in mind, in fact, when they are making these decisions, because they're like, what? They're asking these fundamental questions like, why does the government get to decide what cars we get to drive? In fact, one of the decisions this week is a major blow to the Biden administration's effort and the Newsom effort to electrify cars and get rid of gas cars. So those are the two competing constitutional visions. I think because of the Great Depression and the New Deal, FDR was able to replace our original Constitution with this progressive view. But our institutions, they take a long time, maybe even almost 100 years, but they're reacting back. And they are starting to curb the excesses of bureaucracy. As you say, Bill, of course, there are going to be cases we want government to protect health and safety, but it has gone way too far. It is, we're allowing bureaucrats to replace common sense judgment by you and me. And I think the Supreme Court understands that, is trying to restore that earlier world.
But how do we decide, John, ultimately the limits of freedom? In 1776, they took up arms and they rebelled and they wrote a declaration, declared their independence. In this day and age, it seems, tying back to the courts, everything ends up in jurisprudence. We'll let the courts decide.
Yeah, this is the problem is in order for this kind of restoration to take place, in order to push back against the progressive, this ever-present, omnipresent government state, uh, you can't just do it in the courts alone. You need Congress and the president to agree too. Part of the problem that people are raising already about what the court's doing is that it's throwing the ball back into Congress. So if the court says agencies can't read like the Clean Air Act, for example, which is very vague, to decide how you produce all the power in the country, how we all drive to work, HOV, all that stuff. Well, then Congress is going to have to pass laws that are clearer and
Right.
more detailed and take the responsibility on of making choices for us. That's what we let them to do. But a lot of political scientists say, oh, no, only thing congressmen want to do is get reelected and punt all the hard questions over to the administrative state because they don't want to decide. They don't want to decide abortion. They don't want to decide tough choices like should you be forced to drive an electric car in the name of clean air. But that's what these court decisions are going to force them to do. But it's going to require, and this is your I've heard you talk on your podcast about this repeatedly. How do you get Congress to take responsibility
Right.
for what it's constitutionally required to do? Presidents can do it too. They can start curbing the administrative state, saying, I think Trump was effective in this. Seems like a kind of crazy idea at first, but I think it worked. He basically said for every regulation the agencies issue under my presidency, they have to get rid of two other ones first. That was, presidents can participate in this process. Reagan did a lot. Under President Reagan, the administrative state stopped growing. In fact, a lot of spending under Reagan was for defense. He didn't cut back on the administrative state, but he was the first president in history who stopped it from growing at all. So presidents can do this too. I wish they would all give July 4th, presidents, senators, chief justices could all give, July 4th addresses saying that they are redevoted to the original cause in 1776, which is to place government in our own hands, let us make our decisions about how we want to live. And as you say, get bureaucrats out of our lives.
John, I remember growing up, there was, for example, no seatbelt law. You would just jump in your car and away you'd go. And then as seatbelt laws came into effect, I remember people crying and screaming from the rafters. My God, how can you make us wear seatbelts? Now you just get in your car and you put in your seatbelts, not even a thought. But I don't remember, John, I might be wrong here, but I don't remember anybody going to the Supreme Court with the case of you versus California saying, John, you should not be required to wear a seatbelt. Are we maybe overly litigious this day and age?
You know what? Actually, there was a seatbelt case that went to the Supreme Court, but I think it was called GM versus Nixon. It was the car company sued,
Right.
not the average individual. But no, you're right, Bill. I think, well, one thing is individuals nowadays, I think, expect the courts to be the only place they can go to defend their individual rights. And so you're right, Bill. You've seen an explosion of litigation,
But I mean, in
not
this
just at
regard,
the
John, for
Supreme Court,
example,
but the lower courts.
but in this regard, like Supreme Court, so John Yu's a trucker, and John Yu complains because he has to wear a seatbelt for 14 hours a day driving his truck. The seatbelt, makes it hard to breathe and it's tough on him. So John Yu claims personal freedom, no seatbelt law. It seems that we have these cases galore in this day and age, but maybe a generation ago, 40 years ago, 50 years ago, maybe not so much. Now, is it just because times and mores are changing?
No, I think it's also because people, I think, expect less of politics or they're less right. So, yeah, in the old days, if you didn't like the seatbelt law, you would have gone to your member of Congress,
Right.
right? You would have said, get rid of this seatbelt law, pass a law banning the NHTSA, as far to, I hate to use these acronyms, but the highway people or the traffic safety people from doing this. And instead, now I do think you're right, Bill. People don't expect members of Congress to help. They've bought into this vision of members of Congress as being interested only. This is you've criticized Congress. I know as people in Congress are using Congress to like make themselves into media personalities, right? They're not interested in passing legislation. They're not interested in serving constituents. And so where do you go? You might as well go to court. There you will, because of what we said earlier, the justices do their own work. They are responsive. They have to issue decisions explaining their reasons. And the federal courts do carefully consider every case that someone files before them, which I think is amazing. And so that's the only place Americans feel they can get a fair hearing. So I don't think Americans themselves are litigious. I think it's because this progressive system moved so much power to the bureaucracy, so emasculated the legislature,
It's very
and the
funny.
legislators are happy. Yeah.
It's
So you
funny.
got to go to court.
Yeah, when the immunity decision came down today, I was just following the coverage and reading a little bit, and I noticed that one of the dissents was the argument that you're giving the president too much power and you're basically taking away power from Congress. And then I saw at the same time, well, wait a second, Congress is fundamentally dysfunctional, and that's one reason why these things keep landing at the Supreme Court. So it's an odd time we live in.
Yes. Congress could have passed a statute about immunity long ago. They don't want to get involved. Now, part of it is, of course, that no one like until Biden ever used the Justice Department in this way to go after a past president. So we have no law. That actually the Senate recognizes we have no laws, we have no practice about this because we've never prosecuted a president before.
Okay, John, final note, and we'll make it a quick one. You and I live in California, and our intrepid governor finally gave his State of the State address a few days ago. I included that in my blistering article because it really wasn't a State of the State. It was him just kind of rehashing his inaugural address, and he kept dropping the word freedom throughout it, John. This is something Gavin Newsom loves to do, freedom. This speech rankled me because Gavin Newsom said in no uncertain terms that California 2024 is California in 1939. And the wolves are at the doorstep. Freedom is under assault. We have to push back tyranny. Question for you, John Yoo. Is it 1939 in California? Is it 1939 in America? And as you look at freedom in America in 2024, is this generation more free or less free than the previous generation?
I don't know what Gavin Newsom's talking about. He's worried about freedom in other people's places, not California. I mean, for him, the defining issue has been abortion, and right, the abortion laws in California are the most liberal in the country. And if he's the governor of California, why is he so worried about abortion rights in other parts of the country?
Right.
Right? Well, what aspect of freedom? If there's any aspect of freedom that's under assault in California, it's because of the mismanagement of the California government.
But
Right?
he's
You
saying
have
in
a
so many words, the
huge
election, what he's saying is the election doesn't go the way I want it to. We're headed to dictatorship, folks. Freedom dies.
Yeah, and now that's this. I think now that argument also is over top. First of all, people saying democracy dies. Uh, to me, we're not a democracy. We're a republic, and actually, progressives should be glad we're not a democracy because they're losing a majority of the American people. And as they did under Trump, they're going to use all the elements of the Constitution to try to slow down and stop what the winner of the 2024 election wants to do, just like Republicans do it right now while a Democrat's in office. But these arguments that I really find them outrageous. These arguments that, oh, we're living under a dictatorship, or we're going to live under a dictator, right? Because Republicans say that about Biden now too. I think that goes too far, just like I think these fears of Donald Trump go too far. They said the same thing about Trump in his first term. Right. And actually, I didn't think that we lived under a dictatorship from 2016 to 2020. I don't think things went to an authoritarian turn. And I don't really I think our system is far more resilient than and can resist even the bad impulses of that. What if people think that's what Trump's going to have of one person when they're president? We have had, I think, presidents who've had just as much desire to concentrate power, to use it, to try to change the country. I don't think it fundamentally changed our governing system. I mean, you want to look at people who might have been dictators. You could look at Andrew Jackson or FDR, or liberals sometimes say Abraham Lincoln. But our system maintained itself throughout all those periods. I think through periods of far greater emergency than today.
Yeah, and I think that's why that speech rankles in part because it's saying we don't trust the system. The system's not built, and I would just push the opposite direction. The system is elaborately, wonderfully designed. And today's a good case in point. The founding fathers did not put language in the Constitution about immunity. So let wise people on the court decide what exactly immunity is.
I agree. Look, the founders actually had a remarkable amount of trust in the ability of the American people to engage in self-government. And it's actually the progressive movement, again, which I think has been almost on a 100-year winning streak, which fundamentally distrusts people to make their own decisions. Right? They really do believe in government by experts, and I I don't think that's the value I would celebrate on July 4th weekend. Is thank God we have a constitution that allowed us to give all our power to the experts.
Well put. Well, John, you have a great 4th of July. Have a good time partying by the bay. Please, my friend, though, read the local ordinances. I don't want to read about you getting rung up on thousands of dollars of fines.
Well, we'll find, we'll have the Whalen U GoFundMe page for a California fine paying.
There you go. John, great podcast. Thanks for doing it today.
Yeah. Happy July 4th, Bill.
You've been listening to Matters of Policy and Politics, the Hoover Institution podcast devoted to governance and balance of power here in America and around the globe. If you've been enjoying this podcast, please don't forget to rate, review, and subscribe to our show. And if you wouldn't mind, please spread the word. Tell your friends about us. The Hoover Institution has Facebook, Instagram, and X feeds. Our X handle is @HooverInst. That's spelled HOOVERINST. John Yu's book that I referenced beginning the podcast, it's The Politically Incorrect Guide to the Supreme Court. It is available at good bookstores. It's available at that outlet that named after a big river in South America. Definitely read up on it. Could not be more salient than after what happened today. I mentioned our website at the beginning of the show. That is hoover.org. While you're there, sign up for the Hoover Daily Report, which keeps you updated on what John Yu and his Hoover colleagues are up to. That's emailed to you weekdays. Also, sign up for Hoover's Pod Blast, which delivers the best of our podcast each month to your inbox. Finally, one last note. It's a programming note. This podcast is going to take a break for the rest of July, but we will be back next month with new content, current events, research being done at the Hoover Institution, plus a few historical milestones. I want to do a show on the 50th anniversary of Watergate, which we touched on in this podcast, which I think is very relevant at this time of institutional distrust. Also, Herbert Hoover's sesquicentennial. His 150th birthday approaches on August 10th. We're going to talk about Mr. Hoover's life and times with the biographer of his. For the Hoover Institution, this is Bill Whalen, wishing you and yours a great 4th of July. Let freedom ring.
This podcast is a production of the Hoover Institution, where we generate and promote ideas advancing freedom. For more information about our work, to hear more of our podcasts, or view our video content, please visit hoover.org.